edition of Ask Michael Ehline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel.
Hey guys, how's it going? I'm attorney Michael Ehline. I'm a little bit early. I just wanted to bring you some breaking news so I can share with you why diversity is our strength before we get into the Lane Meyer show. So let's go ahead and take a look at what's happening with Paris, France, and their open borders, the Joe Biden plan for America, and let's see how that's working out for them, guys. What do you guys ready? Let's go ahead and take a look at what diversity is our strength. Sleepy Joe Biden's plan for America was. Here we go. Oh, looks great. Look at our strength, guys. Look at our strength. It's amazing. Oh, it's so awesome. Thanks for the open borders, Democrats. Love you so much. Oh, they're awesome, aren't they? Diversity is our strength. Don't forget that, guys. Remember that. Oh, yeah. Looks great, guys. Yeah. Amazing. Downtown Los Angeles, coming to a city near you, guys. Paris, France. Awesome. Don't forget, guys, remember what CNN said. Diversity is our strength. And if you disagree, you're a racist, bigot, and a homophobe. Oh, man, looks great. Holy cow. Hello. Yeah, that looks so awesome. Yeah, that's what we want for America, right? Let's go ahead and fly in millions of people from all over the world. Give them free cell phones. Give them free hotels. Tell them they don't have to integrate or pass a test. They don't have to learn our language. Just let them in. Look, here's what's coming to a city near you. Oh, it's great. Yeah. Awesome. Great job, globalists. Thank you so much for destroying the world. You're awesome. All right. So, guys, I am attorney Michael Ehline. I am an attorney licensed in California and Texas. And I'm here to give you part 2 of part 4 of the Lane Meyer's plea bargain saga. I just wanted to bring you the latest breaking news from Paris, because we hear from the left how great it is to have open borders and diversity is our strength, letting people into your country who can't read, write, or speak English, who hate your culture, who have been taught from birth to hate the West, and then we just give them free hotels, free SNAP benefits, and free everything, and just let them in the country. So I wanted to share that with you just to make sure you guys understand what open borders mean by giving you an example of what happened in France and the what do they call it? The Islamic Republic of London. What's happening over there as well? Same exact thing. Women running around wearing hefty bags. Locals aren't allowed to say anything negative about them. They're arrested for making tweets and thrown in prison if they say anything bad about these illegal alien foreign invaders who refuse to adapt to the culture of the society that they've invaded. And they just have hundreds and hundreds of kids. And, well, Warren, it's not even about importing voters. In the United States, what's going on is with sanctuary cities and no voter ID, so there's no way to verify if they're voting at all. What's happening is illegal aliens are being flooded into sanctuary cities where they're promised there's no way ICE will get at them. The ICE holds won't be honored by the superior courts there, even in federal courts in some cases. They're refusing to allow ICE to deport these criminals who invaded our laws and came into our country illegally. And they're promised that they can stay there in perpetuity, given free health care, free everything. And they don't even have to vote. So California has 5 additional Democrat congressional seats because of the U.S. Census. And that's why Biden flooded the country with 20 million illegals at your expense. It literally flew them into military bases at night and helped them sneak into our country. Why? Because they knew that if they went to sanctuary cities, that they would never be deported. And in exchange for that, at the next U.S. Census count, the Democrats will pick up about 10 to 15 new House seats at your expense. And there will never be another political party in this country other than the Democrat Party. And I think communist China will be the primary beneficiary of that, Warren. So that's what's really going on. That is the absolute reason why. Good seeing you, Wanda. Good seeing you, Auditors United. And auditors, we're not here to talk about Israel right now, sir. We're here to talk about Lane Myers. But I just wanted to share some breaking news. And if you want to have a bunch of illegal alien invaders flooding into your neighborhood, why don't you invite them into your house and you can pay for them and you can cover all their dental expenses and their free health care, and you can protect your family from them when they've not been taught about our culture and our values. You just let them right into your home. Go for it, brother. It's all about you. Who cares about everyone else and what we want, right? So let's go ahead and get into the Lane Meyer saga. So what's going on here is we're going into part 4 of the Lane Meyer saga. And what ended up happening last time is he was getting ready to enter into a plea arrangement. Hold on a second. Let me open up this bad chicken up. I've got to go down and find. Just give me 1 second, guys. I've got to find the chat replay on this. Okay, here we go. Let me find the transcript and get that thing opened up for y'all. And for some reason, hold on a minute, guys. So I'm trying to show the transcript at this section of 153. There it is. Let me get that open up for you a little bit better. Okay, here we go. All right, hopefully you guys will be able to see this. 150. Dun, 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 dun. I'm scrolling down right now, so just bear with me, guys. Don't get too bored with me. So in any event, Lane was in the process of entering into a plea arrangement with the court. At least that's what it looked like. But so I watched this a couple of times and I was kind of blown away, because being a lawyer, I'm able to look at things a little bit differently than a lot of people. And I kind of thought it was almost genius in a way, what Lane ended up doing. And you're going to get an opportunity to hear Lane narrate to everyone on the record, the facts of what took place in his case. And he hasn't really had a chance to do that in the guise of entering into a plea arrangement. So rather than me narrate and dictate to you exactly what happened, hey, Ryahood, good seeing you. And XGOX, absolutely, free our brother now. I mean, they allow illegal alien foreign invaders who were released from prisons in Venezuela to invade our country and have their way with our women. And they release them from prison just like that. And they say, diversity is our strength. How dare you say anything bad about them? But a native United States citizen who's been living here and born here by birth all of his life doesn't get the same rights as the invaders that Sleepy Joe invited into our country. So I kind of think that's pretty crazy. Give me a bunch of ones if you agree with me. It's insane, right? Hey, Chevy, good seeing you. And me too, Blades. I'm proud to be an American too. And I'm blown away that we had a government that was more concerned about rigging elections using census data than they were about keeping my wife and children safe. And you should all be devastated about what just took place in our country and hope that we get these invaders out of our country soon. Because if we don't, the same people who want tampon machines in the boys' restroom and who want boys competing in girls' sports will pick up about 10 or more additional seats, and there will be no chance at getting them out of our country after that happens. And you better start learning how to speak a foreign language, because English is not going to be on the agenda. You're going to have to press 1, 2, 3, 4 for the language of your choice, and there will not be any integration. There will not be any, you won't even know what being an American is. In fact, you'll have people burning American flags and waving Palestinian or whatever flag, you name it, sub-Saharan African country of your choice, all over the place, as people are pooping in the streets and bringing their cultures and traditions here and not integrating as Americans. So that's what's going to happen. That's right. Give me liberty and I'll provide my safety. That's right, S&S Contracting. That is a great comment. So make sure to hit that like and subscribe button for all you American patriots who put America, your wives and children first over foreign illegal alien invaders. This is the channel for you to come to. And if you believe in legal immigration, where people are integrated into our society, where they have to take a test and they have to take an oath to uphold and defend the Constitution of the United States, and they don't have dual allegiances to other countries, those are the people that I like to have on my channel. So it's really great seeing you guys here. Right on Jeff Hates Pigs, right on Top Shelf Anarchy. I love having all you guys here. And look, I know you guys don't all agree with me on everything, but one thing we do need to agree on is that all of our rights come from a creator, and that America is based on natural law. And natural law is basically codified, for lack of a better word, into our Bill of Rights, and to a lesser degree in the U.S. Constitution, to bind the government by the chains of the Constitution. And the primary obligation of our president is to protect our borders from foreign illegal invasions. And just allowing people to come into the country and giving them everything for free, just so your political party can pick up House seats using the U.S. Census, in my opinion, is high treason. Give me a bunch of ones if you agree. Now let's get back on to Lane Myers. So Lane Myers is a freedom fighter who showed up at a city council meeting. Based on what I heard, it was, I guess somebody was being given an award by the mayor because they're anti-Second Amendment. So they want to have, all of the Californians have moved after they destroyed California and can no longer afford to live there. A lot of them relocated to Arizona like they did in Colorado and started voting to destroy that state the same way they did in California. And of course, the first thing the Maoists do is try to disarm the populace. And so Lane Myers was there with a MAGA hat on, and he was speaking out against it. And when other people applauded for this person who wants to disarm you and take away your unalienable rights as an American, Lane Myers booed. And that was the nexus of this entire case. And so I've been covering this for days now, and we're going to get into the final wrap up. And again, give me a bunch of ones for this is a public service, and Reluctant Prophet for covering this story so well for Lane. And all I'm doing right now is using the transcript that was provided by Reluctant Prophet. And I'm going to, unfortunately, I won't be able to see you guys that well because I'm going to be looking on the screen and scrolling, trying to share the actual written transcript. Forgive typos and stuff like that. This is the YouTube transcript feature. But what I'm going to do is give you my attorney breakdown as a California and Texas attorney. So I am not licensed to practice law in Arizona, nor do I profess to know all of the Arizona laws. I don't wish to practice Arizona law. Everything I'm giving you today is my opinion as an observer based upon general legal principles and how I would handle the case if I was in California or Arizona. And I would presume there's some overlap and there's some similarities. But one thing I will point out is that I do agree that the statute itself, the harassment statute, is vague, ambiguous, unintelligible, and as applied, unconstitutional with respect to Lane Meyer's case. I believe that everybody is guilty of harassment if a so-called accuser or victim says they were harassed, and there is no way around it. And because of that, it is my personal belief that this case should have been immediately removed to federal court because of 14th Amendment due process violations. And I think it's absurd that the prosecutor, in the interest of justice, has not thrown out these charges, especially due to the way they were brought to the attention of the felony county prosecutor. I believe, based on my opinion as an observer, that the county prosecutor was railroaded. I spoke up against the fact that the city prosecutor, who's married to the victim, is literally trying to change well understood Arizona law with respect to audio recording in court, because Lane Myers was audio recording in court. The husband of the victim, who's also a prosecutor, the alleged victim, who's also a prosecutor, doesn't like it. So on his own, decided that he would petition using a bunch of vague, ambiguous and facts, and assuming a lot of facts that are not in evidence, just made up facts, that somehow audio recording in court somehow prejudices people who are in the courthouse. It's absolutely absurd. And of course, the state bar jumped on board, court commissioners jumped on board. They all know this is because of Lane Myers. And I believe it shows a pattern in practice of discrimination against Lane. Now, somebody also posted stuff on that petition claiming to be me, which is not true. And I know there's a lot of people who don't like me because I support Lane Myers, but I only signed one petition, and it was not the one that spoke disparagingly of Mr. Walker. So I just want you guys to know that. I'm not here to speak disparagingly of fellow attorneys or officers of the court. I do believe that what he did is something that was wrong. I believe that it shows bias, and I believe that it shows, by all these other people joining on the petition, shows a bias against Lane Myers through and through. And it tells me in my heart that if this was in California or Texas, that Lane is being railroaded and being denied a fair hearing on the merits of his claim. And so if I was the judge, and I also externed for the California Court of Appeal, I have a background in appeals, criminal defense, and civil rights claims. And now I do personal injury law. I've recovered over $300 million through my law firm collectively with my team. And I've got a lot of experience over 20 years doing stuff like this. And I'm abhorred about what's going on with Lane. So really quickly, and as you can see, I'm a patriot and a freedom fighter, and I'm not afraid to speak out about the things that I believe in. I'm a former U.S. Marine, and I believe strongly in my convictions and my duty to protect and defend the Constitution of this beloved republic for which it stands. And so hit that like and subscribe button. That's right, say good. So hopefully you guys will enjoy my attorney reaction of what happened here at this hearing, and you'll get to hear from Lane's own words, from Lane's own mouth, what Lane Myers, what in his mind, and based on what I've seen, happened to Lane and why Lane was put in the position that he's in today. So let's get into it, and let's hope that there is a federal prosecutor or attorney general watching this, so they can see how somebody who supports the Second Amendment and the First Amendment in Arizona is being railroaded the same way that Sleepy Joe was trying to railroad anybody who had a Twitter account who said anything negative about him or spoke about the true story of the Hunter Biden laptop. Anybody who disagreed that the election was fair, which a lot of us are now seeing that it probably wasn't, that where Orange Man didn't get to take office after the second term, and how the whole January 6th committee was a fraud and how they destroyed evidence, and they didn't show evidence that would have proven that there was never any attempt to overthrow the government. This was all just made up nonsense by the communist left-wing news media. And again, I am a libertarian. I don't really support either political party, but I do support justice. And I do believe that when you have evidence that favors your innocence, that someone who's trying to prosecute you should be forced to show that. And the January 6th committee did not do that. And so we'll get into that in another time, but there's a lot of parallels with what happened to Lane Myers. And if you just don't like someone for their political beliefs and think that they should be prosecuted and persecuted and not be given a fair hearing on the merits of their claim, you're no different than the tyrants that we rebelled against to achieve our freedom from the King of England. And so let's go ahead and get into no, not pro MAGA, buddy. Just, let me see here. So Solin Girl 69 says pro MAGA. Yeah, I am pro making America great again. There's no question about that. But I don't support most of what Donald Trump stands for. I believe that he is an old school Democrat, and he governs like a Democrat. It's just that the modern Democrat Party are a bunch of Marxist communists. So it's kind of hard for me to support that system, right? Where they try to silence their political opponents, try to jail them and use lawfare against them the way that Joe Stalin did. So I don't support that. Absolutely not. But let's go ahead and get into the Lane Myers transcript and let's talk about it. Let's do it. Let's go ahead and play this bad chicken. So right now we're at about 15:53. I'm going to try to push it forward a little bit until we hear some voices.
You don't understand my questions, you need to let me know. Anytime you wish to speak to your advisory council, you're welcome to do so. Just let me know so I make sure you can do that respectfully. Sometimes I talk fast, so if I get going and you feel like you're missing something, let me know.
They say I do too.
All right. Can you state your full name for me, please?
Lane Meyer.
And you, sure. And do you read and understand English?
Yes.
I have to ask everybody all these questions, so just bear with me. Have you had any alcohol, drugs, or medication in the last 24 hours?
No, definitely. In the last 24 years.
I need to let you know if you're not a U.S. citizen, entering a plea agreement can affect immigration status, resulting in you being deported or removed, preventing you from obtaining U.S. citizenship or legal status, even if later these charges are dismissed. Do you understand that?
Is there a way to stipulate deportation as part of this agreement?
Well, I can tell you if you're not a U.S. citizen, it can affect immigration status. That's all I can tell you, and I need to make sure you understand that.
I'm a U.S. citizen. I just want to know if I can.
I think, well, other than being on probation, I think you're always free to leave the country. Probation may inhibit that if you're on probation. All right.
Does it apply to anyone I want to know?
According to the plea agreement under CR 2025-1060, you're admitting to amending count 14, stopping. Make sure I got my stuff correctly here. And that would be a class 5 felony. And then.
What's up, this is good seeing you, brother.
CR 2025-1454 to amend to count 1, aggravated harassment with a court order in place, a class 6 felony. On the class 5 felony, you face a possible prison sentence between 6 months to 2.5 years. And on the class 6, between a third of a year to up to 2 years. Any prison sentence, you would have to serve at least 85% of the 40-year release, and 1 day for every 7 days served in what we call community supervision after your release. Probation is available on both cases and both charges. On both the class 5 and the class 6, probation can be for up to 3 years. It can also include up to 12 months in the penitentiary jail. There's a potential fine of
$150,000 potential fine, guys. So Lane has to basically agree that he's guilty of all this stuff and face a potential fine and still face additional prison time. And we already know that the prosecutors have it in for him. They've been doing everything they could, in my opinion, to taint the judiciary, the state bar, and even the Supreme Court by filing this petition that there's no audio recording allowed. And we all know the reason the petition was filed is because they don't want pro per litigants to be able to audio record. And we also know that oftentimes during crucial parts of these hearings, for some reason or another, the court's audio just miraculously and mysteriously cuts out. My, oh my, very, very odd.
$1,000 plus surcharges. And as to the special terms in CR 2025-1060, the parties agree that at the time of sentencing, pursuant to ARS 13719A, you shall be served with an injunction that prohibits you from contacting the victim. The injunction does not expire and is valid for the unless it is to ARS 13.
Giving up your right to appeal.
Without any restitution, you could the victim for any restitution loss, so that would be loss. You are also giving up your right to a direct appeal that you could challenge as a petition for post-conviction relief. Do you understand all those possible consequences?
Yes, ma'am.
Did anybody make any threats to you or promise you anything we didn't discuss here in court today that we can interview? What we talked about before. Because I did talk to you about procedures.
Yeah, no.
But other than that, did anybody talk to you or promise you anything to get you to enter this plea or make you any threats to make you enter?
My wife.
Well,
I'm
and.
just kidding.
That's pretty
All right,
serious.
so you don't feel threatened or coerced to take the plea, is that correct, Mr. Meyer?
No.
So Lane's saying that his wife threatened him. Well, welcome to the club, brother. That's pretty normal. Let's keep going.
I'm doing this.
Okay,
I know, I got a plan.
all right. And did you sign this plea agreement?
Yes, ma'am.
So you already
Did you sign
signed it.
that after we talked about things here today and after you had the chance to speak to your advisory council, correct?
Yes,
And do you feel that it's in your best interest to enter this plea, given all of the circumstances and surrounding consequences that you potentially face?
I'm taking my advisory council's advice.
Okay. And so going on to amended count 14.
And so that's kind of a genius move too, because he's saying, I'm taking my advisory council's advice. Well, if he's doing that, he has a potential reversal issue on appeal for ineffective assistance of counsel, potentially. Assuming, well, let's keep listening, because Lane's a pretty bright guy. The more I listen to him, the more I see what he does, despite the fact that he's not a lawyer, he hasn't been practicing law for a long time and all that. He seems like he's got a pretty good handle on what's happening to him today. Let's keep going.
It refers to September 12th, 2024 through approximately, and this is on or about, so it doesn't have to be the exact dates, but on or about September 12th, 2024 through February 22nd, 2025. Did you intentionally or knowingly engage in a course of conduct directed towards Shannon Walker, which caused her to reasonably feel for her safety and or the safety of her family?
The state can lay the factual basis.
And I'm not going to lay the factual basis, he's gonna need to lay it. So did you?
So basically, she wants Lane to confess the same way that the leader of the Knights Templar was forced to confess to all of his sins to the King of France and the Pope while he was being burned at the stake, right? And Lane is saying, well, you can have the prosecutor confess for me. I'm not confessing. I'm here because my attorney says it's in my best interest to sign this plea deal. In essence, that's what's happening here. Let's keep going.
Was it emails, phone calls, things like that, Mr. Myers, that you called or sent to Ms. Walker?
That's up to the state to lay the fact in the court to find.
Sir, I need some facts from you. I'm trying to give you some pointers, Mr.
You want the
Resnick.
facts from me?
Let me see, Mr. Resnick might have something that I can follow up. Hold on,
I'm
let's
here to lay the facts.
talking distress / fear under count 1,
Well, delegation is on, like you said.
count 14, excuse me.
So he's saying that's the allegation. He's saying that's the allegation. He's not agreeing that he did that.
So
Yes.
he's saying through September 12th through 2024, February 12th through February 22nd. So the factual basis is that on June 4th, I
Here we
was
go.
arrested for booing at the city
I
council
was
meeting.
arrested for booing.
Matthew Walker started prosecuting me. I began investigating him. I determined that his wife was a government employee for the state of Arizona who worked at the law school and worked with Matt Walker in on special projects.
There you go. So there you go, guys. That is the issue. Lane Myers believed, based upon information that he had, is that Mr. Walker's wife, who's also a government employee and allegedly a law professor at a publicly funded university, taxpayer funded, making her, in essence, a public official or government employee, he believed that she worked with Mr. Walker on these types of cases, and he reached out to her for an interview. So he's getting that on the record. So just so you guys understand what's happening here, it's not like he went out of his way to find the prosecutor's wife who he didn't like, who he just won a case against. No, he's trying to understand, why is it that a public university, public employee, tax-funded employee is working with the city attorney, and how much is her involvement? What is her involvement? So let's go ahead and keep listening, because this is very, very interesting. Most people who dislike Lane, most people don't know what's going on here. So let's go ahead and keep on listening. I think this is very, very interesting. Let's go.
Between the two entities. At that point, I then made a YouTube video, I made a phone call to Ms. Walker, and I advised her that her husband was violating the law, and she had an oath, and I called him a crooked-ass prosecutor. And so then in retaliation, she went and had my wife, her and Stacey Jane had my wife fired from her job.
So that's another issue, is that after Lane had contacted this public employee who allegedly worked on projects with the prosecutor, who also happened to be married to the prosecutor. After he contacted this woman, Lane Meyer's wife, who I believe was a law clerk for either some federal or state judges, was forced to tender her resignation. And again, my understanding is that she is an officer of the court. So she faced a lot of problems potentially with the state bar, and she felt under duress to resign her tenure and ended up becoming unemployed because of this. So I just want you to understand where Lane's head is at right now. His woman just lost her job. He had already won this case that should have never been filed against him because he was basically booing over an anti-Second Amendment rally. At the same time, other people were cheering. So he was not causing any type of disturbance, but just like most Maoists and far-left commies, they want to silence anyone who disagrees with them. And we saw that happen with the Twitter files. And, we can go on and on and on about this, but this is precisely what happened to Lane as well.
So then at that point, I made a video explaining what happened about her role in that. And then I made a video which showed her government information on a government website. And at that point, she went and retaliated by coming to this court and getting an ex parte injunction against harassment by lying to Judge Walton.
Okay, well the harassment is after.
No, she got an injunction for harassment.
Okay.
By lying to Judge Judge Weiland, and then the next day she came dismiss that.
So she dismissed that. And so in California, when you dismiss your request for an injunction or a restraining order, you cannot bring that again. It's done. It's over. Unless there's substantially new facts. And the issue was, from my understanding, is she'd failed to mention the YouTube video in the first injunction. And so those were facts that were already known. So for her to amend it without seeking leave to amend, but instead dismissing it, if that was in California or Texas, the judge sua sponte would not be able to receive that. The judge would have to out of hand reject that new filing. I don't know how it is in Arizona, but I assume there's a similar situation. Let's go.
Injunction for harassment, unlawfully issued again by Judge Walton after saying if you dismiss it, you're not eligible to get another one. She was then granted another one without testifying to any facts or acts contained in the petition. I was unaware of that until I was served the injunction, and then once I was
So she went ex parte again. So ex parte means outside the presence of the accused, and of course, this comes back from ancient biblical principles as well as the Dane law and all of the common law of England that was imported to the United States. And you have the right to face your accuser, except in very, very rare delineated circumstances. And in this case, there was basically a finding of against Lane, or at least a hearing without Lane's presence. And he didn't even get notified of it until after the injunction was issued. And I've always had a problem with these types of injunctions. And the fact that she's married to a prosecutor, the same prosecutor who Lane just beat a case against, I mean, you don't find that to be a little odd and a little bit disturbing, guys? Someone who wields that much power could basically use their friends in the judicial system, their connections with the courts, the bar, to go after someone they just don't like. And it has the appearance that ego could have been involved. And here he is now having a injunction issued against him outside of his presence. So you can see, just put yourself into Lane's point of view, how he would feel. So at least we're finally getting an opportunity to hear it from the horse's mouth instead of trying to have me paraphrase things. You'll hear directly from Lane what his state of mind was and is as a result of this entire process. Let's keep going.
The injunction, I made a YouTube video showing a publicly available public court document which contained public information about a government employee. At that point, I had a hearing with Judge Griffin in which he said all my videos that were previously posted are allowed to remain posted because it's my First Amendment right to have those videos up. He would not be ordering them taken down, so I left those videos up and I moved on from November to January when a judge in this court made me aware of the hearing that supposedly disappeared on October 9th. When I became aware of that hearing, I paid Tracy Robinson $35 for the record from the court reporters. I then posted that hearing on my YouTube channel, letting the whole world know how Shannon Walker committed perjury 33 times in 9 minutes with Judge Weiland. Went back the next day and somehow issued an injunction based on one alleged act, and then was told that the hearing will be sealed unlawfully. I thought that was newsworthy, so I made a video. I posted that. At that time, I had an injunction which unlawfully restricted my ability to disseminate information about government employees. I knew that it was unlawful and I was appealing it, so I went ahead and made the video anyway. I exercised my First Amendment right to disseminate information about government employees, and that was a 4-part series. I made 4 videos about her lies in court, her Judge Walton's issuance of the injunction, despite her stating in the hearing that if it was dismissed, she would not be unable to do it. She did it anyways. I thought.
And so here's the issue: if I would have made that video, or that 4-part series, or if you would have made that video, if anyone else would have made that video, it would have been protected under the First Amendment. But allegedly, since Lane made the video, even though it's all public information, there's nothing confidential about it, Lane is being found in violation of a court order, which allegedly amounts to a felony. So it's just mind-boggling to me, guys. So let's just keep listening, because this is blowing my mind, and it's really interesting to hear Lane's point of view. And by the way, give me a bunch of ones for Lane. He's doing an amazing job at making his arguments now without cutting people off, without cussing and swearing. This is the kind of Lane Myers that could be one of the best trial lawyers in the country. With that steel trap mind of his, I do believe that Lane really could be something. I mean, I think that he could be a phenomenal trial lawyer if he could just maintain the demeanor that he's maintaining right now during this oral part of the proceeding. Let's keep going.
So that was newsworthy. I own a news media company in the state of Arizona, so I thought my freedom of press would outweigh the injunction. I then posted that and then moved on with life on February 22nd. On March 7th, they indicted me using the detectives lied to the grand jury, got an indictment, and then I was served that indictment on March 12th. I came to court on March 14th and was arraigned on that charge.
So, Mr. Myers, I heard you say that you made some calls.
I made 1 call.
A call to the Walker. You did 4.
Prior to the injunction.
Right, that would be within the September 12th, 2024 through February 22nd.
Yeah, I called them up their voicemail saying that Matt Walker was a crooked-ass prosecutor.
And then there were 4 videos that you posted.
Well, you'll recall that the alleged victim stated that Lane Myers had made multiple phone calls, and my understanding is that she had been sworn in under penalty of perjury when she made those statements, and I believe that's why Lane is saying that she committed perjury. Give me a bunch of 1s if I'm correct on that observation. Give me a bunch of 2s if I'm wrong, and put it in the comments so I know, because I want to be accurate here.
Containing the FTR that I paid $35 for from the court reporter.
And so you posted some things that sounds like you knowingly engaged in a course of conduct toward Ms. Walker. What I want to know is you also, according to this, which would cause Ms. Walker to reasonably fear for her safety or the safety of the family. So with regard,
there's no threats.
So there can be direct threats, which are pretty obvious, and then there can be things that just make you
Oh, there's
fear.
only true threats.
I can supplement a little bit.
No, she said she wasn't saying nothing. She wasn't saying nothing.
Then sir, I'm gonna reject the plea, because I don't have facts right now. I need to
Those are the
know,
facts.
so let me
Those
hear
are the
what,
facts.
let me hear what this file says.
Your Honor, he engaged in posting Ms. Walker's information regarding her work email.
Her work email is online on the university's website, okay? So by reposting something that's publicly available, guys, I'm not seeing it. I'm not feeling it at all. It's a government email that you can get online. What do you guys think? Do you think this is overreach by the prosecutor? It sounds like it to me.
Her work address, her work phone number, and then he would put it onto his YouTube page, and then he put it up there. He would encourage his followers to contact her, in which
No, he encouraged his followers to petition the government for redress, which is their right and your duty as an American, in my opinion. What do you guys think?
did, and they left her harassing messages.
Now, again, that's assumes. So I would immediately say objection assumes facts, not an evidence. We know that many people did call that phone number and send emails to that email, but we don't know if those were Lane Meyer's followers. There's no evidence proving that those were Lane Meyer's followers. We know that Double Douche and all these other guys also who didn't like Lane could have done that. We know that other people out there who dislike Lane Myers, just like they posted false things that say attributing them to me, saying that I wrote these statements opposing Rule 122H or whatever it is, or 211H. That happens all the time because these YouTubers, they have too much time on their hands. Remember that song? I think it was called by Styx, Too Much Time on My Hands. So these guys just have a lot of time on their hands, and we don't know. There's no evidence. There's no proof that any of these people that left the harassing emails or phone messages were people that Lane Myers had do that. There's no way that we could ever know that. So that is, to me, that assumes facts, not an evidence. It lacks foundation, and it's argumentative. What do you guys think? I mean, I just think that's crazy that she's able to just say, beyond a shadow of a doubt, the reason why these messages, the reason why these emails were sent is because Lane Myers told them to do that. No, that's not evidence, guys. That is an opinion. It calls for speculation. And if he's before a jury, guys, I do believe that if he had the right lawyer, and he may be the right lawyer for himself, but at trial, just on those arguments alone, there's no way a jury could convict. There's no way this would ever go beyond a reasonable doubt standard. There's just no way, guys. Give me a bunch of ones if you agree. Give me a bunch of twos if you don't. Let's keep going.
That also ranged from things like wanting her to be raped and killed. And so he
Okay, so did you hear that? I mean, she's literally attributing statements like these people wanted to R and unalive this person, and she's saying it's because of Lane Myers. We don't know if that was somebody who doesn't like Lane who left those messages. We'll never know. And so for her to argue that as fact without any evidence, to me, is improper. And that I would file written objections to that evidence, and I would demand findings on the record by the court as to whether or not my objections were overruled or whether or not they were sustained, because I believe it would be an abuse of discretion to sustain an objection based on such shoddy evidence, such weak evidence. Basically, the prosecutor is being allowed to argue things as if they are true when there's no evidence showing that they're true. To me, it's just unbelievable, the unprofessionalism in these arguments with no factual or legal basis other than speculative opinion. Let's keep going.
These messages kept coming in. He was made aware of these messages. He's indicated numerous times that he was aware that his followers were reading these type of messages, and yet he continued to put up her information during this time and causing those followers to continue that contact with her. So he had initial contacts with her where he left her that message. He went to the law school looking for her, but then he also would use his social media to encourage followers to continue that contact.
Do you understand that all of that would have made her fear for her safety, Mr. Meyer? Then do you have any other reason why she would fear for her safety?
Because she doesn't understand that she's taken an oath under ARS 231.
Taking an oath doesn't mean you have a right to be harassed,
I didn't harass her.
great fear.
It's an allegation other people did, not me.
So, but sir, if you're promoting them and
I
encouraging
promote
them.
anybody and I didn't encourage them. There's no factual basis.
That's right. There's no factual
Thank
basis.
you, Mr. Meyer. At this point, I can't take your plea because I have a factual basis, and part of that is that Shannon Walker to reasonably.
The only way they're getting a conviction against him is if he admits on the record to something that he didn't do. So bravo to Lane for not allowing them to do what they're trying to do to him.
Feel for her safety or the safety of her family, and if you can't, and I'm fine with that. If you can't do it, so you know.
I'm just curious if you're asking me to admit to that because the state even just said that other people don't.
And that you were aware and you continue to post for address and information, and you continue to encourage people.
They posted their address. So I'm confused because I said the state to do it, and they refused to do it, and now they're disputing what I did.
Mr. Essen?
I guess the issue is, Judge, what Mr. Myers did was he posted publicly available or publicly facing information that's on the
That's right.
So obviously he has no control.
Amen, brother.
Parties. You can't stop them from doing
And
whatever.
I also didn't encourage it, that's a lot.
And yeah, I mean, again, if I cover a news story, if I were a news organization,
Correct.
and I cover news stories, deal with it all the time, you may wind up getting phone calls and comments and things from third parties who see the news story, but it's not like Hagan I or TV 13 have any control of that. And so they would want to be held liable or charged with, harassing.
Then I don't have a basis.
No, I agree, and that's part of the First Amendment title.
Yeah.
I mean, you're allowed to use the record, you're allowed to use the grand jury transcript, and if you read the grand jury transcript.
Sure, I won't, first of all, I don't have it in front of me, it gets sealed, I can't even pull it up on Agave.
Oh, I thought that the rule was that you could use anything on the record.
I can pull it up and all that, but even if I do that, I have to have you agree.
That was.
And all the facts that are in there are accurate.
And the grand jury does.
And yours already told me you don't agree with that.
You're saying agree. Well, what the grand jury says and what Rachel Stiles just said are two different things.
There you go.
What I have to have you say to me, Mr. Myers,
You heard that? The Lane Myers, who has apparently had access to what the grand jury said, disagree with what Rachel Stiles' version of the facts are. That she basically using conjecture and what I believe are specious arguments based upon speculation and ambiguities has created her own make-believe, made-up facts to try and get Lane to agree to these facts that she's made up that are not supported by the evidence. And that's the problem that I have with what this prosecutor is doing here. I think it reminds me of Letitia James and what she did in her case. Just a completely different set of facts than actually existed. And maybe she'll get lucky and get a biased jury like Letitia was able to do, but I'm not sure.
is that on or about September 12th, 2024 through February 22nd, 2025, you knowingly engaged in a course of conduct. I think I have that because I think I have emails that you've agreed that or a phone call you've agreed you've made and multiple postings for videos. So I can take that as a course of conduct. So I've got that part of it, which would cause Shannon Walker to reasonably fear for her safety or the safety of her family. I have to have
That's
something.
subjective.
So if anybody else, I just have a question for you guys. Do you think me covering this story could somehow makes her in fear of her safety? This is a public official, a public employee, married to a public official who prosecuted Lane. And I'm just covering a news story about it. And if I was to post her publicly available, you can get it anywhere online, government email, government place of address, which is posted online by the government. If I did it, does that give her the right to fear for her safety? I'm just asking you guys, how is that fair? I mean, any government employee now could go after anyone. I feel harassed because someone discussed the fact that I have a government email, that I'm a government employee that works at a tax-funded university, and I happen to work on projects with the prosecutor's office, and somebody who just beat my husband in a case that he prosecuted is now contacting me to find out why and what I'm doing with the government. Why am I working with the state? What business does a law professor or a government employee at a university have working with a prosecutor's office and wanting to know what's going on? So, yeah, I mean, does that somehow now make me a harasser, liable, or subject to some criminal code for harassment? I don't think so. I think that's crazy. I think we have a First Amendment for this. What do you guys think? I want to know what your opinion is. Let's keep going.
Well, I have to know that you agree that what you did made it reasonable for her to fear for her safety, the safety of her family. And I don't have that right now, and I'm okay not having it. I'm not asking you to give me something you can't say, but if it's reasonable for her to fear based upon these phone calls and the things that she was.
I know a lot of weak-minded people who are afraid of their own shadows, but that doesn't mean that it rises to the level of criminal conduct against somebody that they're afraid of. What do you guys think? Give me a bunch of ones if you agree with me.
Getting that you initiated by putting her information out there. It may have been a public-facing website, but you put it out there in a different way. If you would agree that that reasonably resulted in her having a fear for her safety, then I can move forward to the second one.
You're asking me to admit to allegations that are not made against me.
And I'm just finding that's how you're doing it.
You're saying that you want me to say that I believe Shannon Walker, it was reasonable for her safety based on my conduct. But the state just offered evidence of other people's conduct saying they would do this or that. I never said I would do this or that. I never encouraged people to do that.
That's right. Bingo.
So-
And that's the winning argument at trial. He never told anybody to threaten this woman. He never told anybody to do anything to try to harm her. But I know of plenty of people who hate Lane Myers who would call this person with the hopes that it would get Lane Myers in trouble. And that is where the problem lies. And I don't see how this rises to the beyond a reasonable doubt standard. And that's why I believe that the prosecutor is praying to God that she gets an admission and confession out of Lane, because I don't believe she'll win this case at trial. And even if she somehow is able to get some felonies for this, are you kidding me, guys? Really? Even if she is able to get some kind of a conviction, that statute, that harassment statute, is unenforceable as a matter of law had this been in California or Texas, based upon my opinion as a lawyer of over 20 years in practice, having externed for the California Court of Appeal and having done multiple appeals, having done habeas cases, petitions for writ of certiorari. I don't see that this case could ever win could be upheld on appeal. That's my God's honest opinion. I think that this is like the last chance that this prosecutor has to try and get a conviction against Lane. The only way that they're going to get anything out of him is to continue confining him. And if the allegations are true, continue having correctional officers trying to beat him up and harass him while he's in jail. I think that's the only way out of harassment and fear is the only way they're going to be able to get some kind of conviction or confession out of Lane prior to trial. Give me a bunch of ones if you guys agree.
Mr. Myers, so the same thing happens to me again taking a drug plea. It's charged for sale, the plea is for sale. They can admit they possessed it, but they deny that they did it for sale. I cannot accept that plea. It may be a crime to possess a drug, but a plea agreement I have is possession for sale. I have to have a count. I have to have the drug and I have to have the sale. In this case, I have to have the conduct, which I'm comfortable with. And then I have to have, which would cause Walker to reasonably feel for her safety or the safety of the family. I have to have that. So if you can't acknowledge that your conduct would reasonably result in that, I'm okay with that, but it just means I can't take.
But again, it wasn't his conduct. Other people who probably don't like Lane, and I'm sure that he'll be able to provide overwhelming evidence at trial of all these people who have an animus against him. And I believe forensically, we could probably find out their phone numbers as well as their IP addresses with some kind of a forensic expert. And we could determine where this information, who the actual people were who made these comments and these statements. And by the way, guys, where's the criminal investigation? Why isn't the prosecutor's office trying to find out who these people are who made these threats? There were voicemails. Why aren't they trying to find these people? They know it wasn't Lane Myers. Why don't they try to find out who these people are? Because I think what you're going to find is that those are the same people who have been harassing Lane and his family, the same people who allegedly shot out his windows or threw rocks through his windows. I think you're going to find out that these people realized that they could try to create a false appearance of impropriety against Lane. And exactly what is happening happened. And I'm just blown away. Where is the criminal investigation? Why aren't there people trying to find out who the people are who actually made these statements? Because I think that would be due diligence. And I think at trial, I would argue, hey, the evidence was within the prosecutor's ability. I would argue under evidence code section in 412, when stronger and more powerful evidence was available at trial, but wasn't introduced at trial, the evidence that is produced shall be viewed with distrust. Look, the prosecutor has it within her power to do a real investigation to find out who these people were. She has the duty to provide exculpatory evidence to prove whether or not it was actually Lane that was responsible for these calls. To out of hand just say, oh, well, because Lane gave out the phone number and email, that means anyone who contacted her was doing it at the request of Lane. And the threats that they made were because it's what Lane wanted. No, you have to look at their motive, Madam Prosecutor, and you didn't do that. You just assumed a bunch of facts, not an evidence. You were able to convince a court with no evidence somehow or another to issue some kind of a preliminary injunction and jail him. And then he was promised that he would have access to a law library so he could defend his case. And it turns out that somebody must have known that that law library had been closed for at least 2 years. I think everybody knows what's going on here. And to me, it looks really, really unfair. It has the appearance of impropriety and unfairness. And you're supposed to look up for the rights of the defendant. And I don't see that happening in any way, shape, or form here. It's all just conjecture and speculation. And if I was the trial lawyer, that's what I would be arguing to the jury. Let's keep going.
The plea, because I have to have both factors.
So my question is where does that stem from? Because the rule says that the court needs to find the facts, not that I need to admit to them.
Well, I need to have a factual basis, and I get that from individuals.
Just need to do it.
And then I asked you to agree to it, and you didn't agree to what they said.
Because the rule doesn't say that I'm required to admit anything.
So, sir, I will not take a
So that's
plea.
a personal, that's your personal
That's the way,
interpretation of.
my view of the law is that the defendant has to enter a factual basis and enter a plea. And they need to do so knowingly, intelligently, and voluntarily.
Is that
so
your
they either
version
have
of Rule 17?
That's my view of law. I will not take a plea just because the state rattles off a bunch of stuff and have defendants sit there quiet. Every plea I've ever taken on 9 years on the criminal bench included a factual basis that somebody provided and that the defendant agreed to. If you cannot agree, no problem whatsoever. I just won't take the plea, sir. I have to know you agree to the factual basis. If not, I will not accept it.
So I'm.
And you're welcome to try Judge Metcalf. I don't think he'll accept it either, but
Well, you're saying that, when you said the law, or that you're saying you need it based on the law. Are you saying based on Rule 17? Because the way I read Rule 17 in the case law is that the judge is required to make that finding based on the record, not on me admitting it.
I can look at facts from the record and then I can look at you and say, do you agree with those facts? And if you agree, that's fine. I will
Well, if
not
you look
take
at the
the
record
plea.
into that, I would be more comfortable than with the state, just like you said, just rattling off some stuff and then saying, do I agree? Because
So
what she
with
rattled off is not what I'm trying.
With what you did, the course and conduct of the posting of the videos, the phone call, with that, was it reasonable for Ms. Walker to fear for her safety or the safety of her family? Was that
I
reasonable?
don't think that she should have been fearing for her safety.
Okay, then I don't have a factual basis. So, and which is fine.
I agree with the
No
judge.
problem. I am gonna make sure that, Michelle, can I have you?
Your Honor, I have a Donald record because after this, we're gonna pull the plea. So
Okay.
we're gonna be done and we're just gonna go to trial.
Then let me hold on to this.
Good, you should go to
If
trial.
you can't agree that him posting those videos caused those people to reach out to her and that they wouldn't have reached out to her but for him doing that, then there's.
I think they reached out based on her lies in court.
So I think we don't have it.
So it sounds like we won't get there, so we're just gonna.
That's why I reached out.
Let's just go ahead and
Yeah.
get it on,
Sure.
and we're gonna pull the plea after today. We're
Please,
just gonna-
please listen to Ms. Stiles. Mr. Myers, I'm gonna ask you some questions when she gives us this information. Go ahead.
So, Your Honor, I'm gonna go through, I'm breaking them up, they'll be consolidated for trial purposes, but I'm breaking them up into segments just so that on release allegation gets the 2-year section. So, in this matter, he would have a class 6 felony that would carry, all of this has been mandatory because he does have prior felony convictions.
I mean, this just blows me away. We've got illegal aliens that have snuck across our border that are wreaking havoc and threatening people's lives, attempting to unalive them. And they get out on no bail holds. They just get out. But for some reason, Lane Myers, apparently because it involves a prosecutor and his wife, is looking at life in prison. Isn't that amazing how government employees seem to have the ability to protect their families more than you and I do against illegal aliens that our government flooded this country with? To me, this is just absolutely atrocious. Let's keep going.
And, Your Honor, he's not paying attention, so.
Mr. Myers, make sure you're listening. Okay, the class 6 public.
What is that we're doing here now?
We're getting a Donald record to make sure that you understand.
I thought you said that when you were rejecting the plea.
I am, that's why we have to do a Donald record. Go ahead.
So for the class 6 at trial, he's facing
33 years.
up to 2 years. For class 5 at trial, he's got 5 of the class 5, so each one carries a range of 6 months up to 2.
She's so proud of herself that she gets to sit there while Lane's locked up and threaten him with 33 years in prison for posting a YouTube video and allegedly making one telephone call, guys, based upon what Lane is claiming is perjurious testimony by the alleged victim. Right? And then, of course, the court went ahead and sealed the record after it said that it would not entertain a new injunctive petition. I mean, there's so many things wrong with this case, guys, if this was in California or Texas anyways, that I just don't see how any prosecutor in their right mind would even file these charges. Let's keep going.
2.5 years. And then on the class 3, for the first case, you'd face a range of 2 to 8.75 years. Again, these are all prison mandatory, and
They could technically be stacked, correct, because they're different dates?
correct. And then under the second case, we would have, it's increasing the range because of the fact that we have the on-release allegation. We have 2 of those class 5s, each of them carrying a range then of maybe 2.5 up to 4.5 years. We'll have added 2 years. And then with the class 3 offense, we would then be dealing with 1 on release, so then it's a range of 4 to 10.75 years. So at trial, he would be facing a minimum if he's convicted of
I mean, Mao Zedong would be proud of this woman, in my opinion. Let's keep going.
everything of 4 years up to 43 years in prison.
For YouTube
All right.
videos.
So, Mr. Myers, did you hear all that?
Yeah, do I need to add up how much money and damages they're gonna pay me if I'm acquitted?
Sir, that's not what we're doing on the dollar record. On the dollar record, I need to make sure you understand that at trial, if you're convicted as charged, so it has to do with everything. The minimum you face would be 4 years in the Department of Corrections, and the maximum would be 43 years. And that's because they can take the first class 6 and sentence you to 2 years on the maximum level, 2, and then there's 5 class 5, so they can each be 2.5.
Actually, those class 5s are only class 6s.
Okay,
They,
well,
they're
that's,
mistaken, they label them as a class 6. I have,
that would be a different argument at trial. I'm saying
well,
the
you
way
said you gotta
it's
make a
charged.
correct record, right? You gotta make it,
So
so
just
it has to
remember,
be true that,
as it's charged, and as it's charged as a 5.
Oh, I
So
see.
there may be a different argument. There may not even be all these convictions. So I'm just saying the worst case scenario. You can convict of everything as charged. Okay, so as worst case scenario, as charged, you face between 4 to 43 years because of the statute, okay? Worst case, all right? The plea agreement and probation is not available. Even if the judge wanted to give you probation, doesn't matter, the judge doesn't have a choice as charged, okay? If, with the plea agreement, probation is available, so that's the first big difference. It's available as charged, it is available under the plea. Under the, as charged, you face between 4 to 43. Under the agreement, you face between 6 months to 2.5 on one, and a third of a year to 2 years on the other. So worst case scenario, running them consecutive, you face between 6 months to 5.5 years. It's something big over here. Isn't it?
okay. So I just wanna clarify that,
Sure.
the maximum on the plea bargain is more than the minimum on the thing you just calculated.
Correct. So the maximum under the plea agreement, which would mean that the judge had to aggravate it, would be 2.5 years on the class 5 with the consecutive 2 years. So this is what under the law judges have to do. You start at the presumptive. So on the class 5, the lowest is 6 months, the presumptive is 1.5 years, and the highest is 2.5. When a judge looks, and if you look at the statutes under sentencing law, a judge has to give mitigating factors to go down from the presumptive and aggravating factors to go up. So you're right. Under the plea agreement, the 2.5 to 4 years is 4.5 years is more than the minimum you could face if you went to trial. To get to that 4 at trial, if you were convicted of everything, the judge would have to substantially mitigate all of those charges, which is unusual in a case where you have two different cases to run both of them all current and together.
You already
It's
said
just
you rejected
unusual.
the plea, right?
Yeah, I just want to make sure you understand, because that's what's important.
Even if I agree or not, you said you rejected the plea.
I will reject the plea if you cannot give me a fact.
And just so you guys understand, this is why 95% of cases result in a plea agreement, because the prosecutors will use fear and intimidation, and they'll lock you up if you don't go along with the story in many occasions, until you basically have no choice but to plea. So it's about punishment, fear, and intimidation. 95% of the time, it's going to result in a conviction. But yet, if you're an illegal alien invader who snuck across our border and violated our laws, there's a high probability you're going to get out of jail and just go right back out on the street and do what you were doing. But if it's something where it upsets a government employee or one of their family members, look at the difference, guys. This is why I got into civil rights law, because I'm sick and tired of the government and their family members and their friends getting better opportunities and better chances at a life in this country than the very people who fund them. And I'm not saying that's precisely what happened here, but it does have the appearance of impropriety. When I look at the totality of the circumstances, it makes me sick to my stomach. I'm not saying that Lane Meyer is Jesus or the Messiah or anything like that. But what I am saying is it does not appear that he's being treated in a way that would be commensurate with anyone else who had violated a non-government employee's rights. And this is the issue that I have. So let's get back into it and keep on watching. Very, very sad. It makes me sick to my stomach to think, gosh, I almost wish that I was part of the political class so I could get all these additional protections and additional ability to persecute and prosecute people who go against me, my family, or my friends, right? Or my buddies on the bench that I go golfing with, for example. Let's keep going.
Factual basis. If you want to go back and try again, I'm willing to listen. I just need to make sure that.
Where's the delineation between my factual basis and you accepting?
So I can only accept a plea if knowingly, intelligently, and voluntarily enter it. I can only accept a plea for that. To knowingly, you've got to know what you face. You got to understand the conditions of the plea. You also have to give me a factual basis about it. I need to know you're pleading guilty to these charges. If you're willing to do that, I will take the plea. If you're not willing to do it, I cannot take the plea.
Can we use the statutory definition of knowingly under ARS 1059?
So, sir, I'm not going to take this plea. I can't make it any more simple than this unless you agree to me that based upon your course and conduct, Ms. Walker was reasonable to fear for her safety or the.
Hey, listen, guys, I'm going to tell you right now, and I'm saying this just as a free man upon the land. I would never plea to a case like this based on these facts. Someone is making phone calls or threatening this person allegedly. We don't even know if it's one of her own friends that was put up to it to try to nail the coffin shut for him. And if I'm before a jury, you better damn well believe that I'm going to be making these arguments. And if it turns out later after trial that the prosecutor was withholding evidence like that, I would definitely be going up on a quorum nobis instantly. If there's any kinds of new evidence or new facts, this case is toast. And so it seems to me that if I was the prosecutor, I would be like, if I try to bring these charges and he gets a jury that like an old school jury, not these California transplants who are scared of their own shadow and who are offended by everything but accountable for nothing, right? That I'm in trouble. If I get an old school open carry, real Arizonan, not one of these transplants, and they get on the jury, it's going to be a mistrial in perpetuity. And so absolutely, I'm going to be trying to intimidate and terrify the criminal defendant, alleged defendant, to try to sign off on a plea agreement. And the only thing that she really has over Lane right now is the fact that he's incarcerated. It's in the fact that he's alleging that he was attacked by COs, that he's in fear for his life. So anything that he does enter into is obviously based on fear for his safety. It just smells like a rotten fish, guys, from the head down. Let's get back into it. But honestly, guys, I mean, you don't really see me normally getting emotional or excited about things, but this really has a bad taste. It's given me a bad taste in my mouth. We have no idea who made these phone calls. We don't know that they were made because of Lane. Lane never told anyone to threaten this person. All he did is the same thing that Chile de Castro did. And he got his case reversed on appeal as well. And that was, I encourage everyone to petition the government for redress because I'm being falsely accused and I was poorly handled by government employees. What makes government employees more special than the taxpayers who cover their pensions and their livelihoods? Why aren't we the people trying to form coalitions where we do recall elections and we run for political office ourselves to get these people out of office? That's the question that I have. Does anybody have any answers for me in the sidebar?
Safety of her family. If you can tell me that based on your course and conduct, that which would cause Ms. Walker to reasonably fear, I can take the plea on that count. I still not for the other one, but I need to know that it was reasonable based upon the way this is charged.
Reasonable for her to fear for her safety.
Or the safety of her family. It has or.
You're asking me for my subjective.
I'm asking you to agree that the course and conduct you did would make it reasonable for her to fear for her safety or the safety of her family.
And Judge, I apologize.
That's okay.
I'm really not trying to muck this up, but I think what we're caught up on is what the court's asking, and probably the problem statutorily in this statute, is it requires the defendant to put himself in the place of the.
And that's precisely why I believe that if this was in California or Texas or before a federal court, that the statute itself is unenforceable. This statute is so horrible. And that's why the Arizona state legislature is already in the process of revising it. And it's why I believe the original judge should have ruled in favor of Lane on the statute as applied and as it's being enforced. It's an unenforceable statute if this was in federal court where I'm licensed to practice or in California or Texas. Now, we've got another lawyer who was co-counsel to Lane who agrees with me with respect to Arizona law. And it appears as though his current associate counsel on this case is making the very same argument. And it is a solid argument. I mean, how absurd. This reminds me of something right out of the Soviet Union or communist China. Or what they do in Canada, right? Guilty until proven innocent, a vague and ambiguous statute. It could mean anything to anyone depending on their mental state of being. It's just not something that I feel is fair. I think it's denying Lane due process. Let's get back into it. Oh, let me try to get it in the right screen. There we go. And here we go.
The victim. And whether or not it's reasonable for her to fear for herself.
Right. So, like, for example, is it reasonable for a man to think that he's a woman, even though he's not a biological woman? Well, to that particular man who's suffering from gender dysphoria, it is. But to anyone else like me, I'd say this guy's nuts. This is a dude, and stay out of the freaking ladies' room. If you do, and I'm around and my daughter's in there, we're going to have problems. So you understand how this works, guys? That's why his lawyer is saying this. Lane can't put himself in her position. He doesn't know if she's of unsound emotional state where she's offended by everything, right? Let's keep listening.
The safety of her family is up to her, right? I mean, anybody who actually has that fear feels it's reasonable. I mean, nobody's going to run around and say it's unreasonable.
She's certainly entitled to feel how she feels.
That's right.
And I understand how what both of you are saying. I just think under the law, there's many times where we've used reasonable. Is it reasonably that when you do X, Y, Z, this would happen? Is it reasonable that by putting out her address, her phone number, her information, and I understand, Mr. Myers, that they're on a separate public website, but by doing it with regard to the other statements that you made, is it reasonable to believe that that would then result in her having a fear for her safety or the safety of her family?
So are you already saying that
The jury will have to determine that reasonableness too. So
are you saying
In my opinion, the Court of Appeal is going to have to determine what reasonableness meant, or the Supreme Court, because based upon the clear wording of the statute, he's already guilty because it's based upon the victim's state of mind. It's not based upon reality. Anybody could say I was in fear, and you, my friend, are now guilty of harassment under this statute. Let's keep going.
Are you just skipping the intentionally or knowingly, or are you saying you find that?
So you have to knowingly engage in a course of conduct. I'm okay finding that.
You
because
have to knowingly engage in conduct that would make her fear for her safety, not just
That's-
engage in conduct.
right, so, but what I'm trying to make it so you understand where I'm hung up.
Because I read the ARS, because, this legal jargon is the technical nomenclature of the law. The law gives you the definition of knowingly, not Lane Myers or Shannon
Okay,
Walker. Or
so sir, I need to know that you agree that it was reasonable based on your knowing conduct of putting her address, phone number, information out.
So let me ask you guys a question. I just want to ask you, if I'm an investigative journalist and not Lane Myers, and I do a series of videos and I put out her email and I put out her all on a public website. See, this government employee's contact information is here. I encourage you to petition her for redress because it seems like something's not right. It seems like a public university or a law professor should not be working with the prosecutor's office in some kind of a secret arrangement that the public isn't aware of. And so I encourage you to petition this person. And here's her phone number and here's her address. Does that now make 60 Minutes liable for harassment? Does that make me as a citizen journalist liable for harassment? If someone calls who doesn't like her, who doesn't like me, who starts talking trash and says, hey, I heard from Lane Myers, F you, I'm going to come after you, I'm going to unalive you. Does that now make me liable for harassment? Because if I'm the trial attorney, that's what's going to go before the jury. And if somehow or another this statute is not reversed by the time of trial, the Court of Appeal is going to have a real pickle, or Court of Appeals, I guess in Arizona, is going to have a real pickle. If I'm an appellate justice, I am going to throw this thing out like a hot potato. I am not going to want any of this smoke. None of it. I'm telling you right now, justices in the appellate courts, they are not trying to get reelected as a superior court judge or get appointed by the governor. They now have the ability to look at it from an unbiased point of view. And if they want to get appointed to a higher court and they want to stay in their job, they're going to do the right thing, guys. And here, I think the legislature has already made it clear that they know the statute is bad. It's a bad statute. In my opinion, if this was California or Texas, it would be unenforceable, and no prosecutor in their right mind would bring charges based upon this biased, vague, and ambiguous language of the statute, which allows anyone to interpret it any way they want to get a conviction. Give me a bunch of ones if you agree. Let's keep going.
They're online, that you knowingly doing that conduct, and by calling her, would reasonably result in her fear for herself or for her
Could you imagine a judge asking Dan Rather, right, or Peter Jennings, or some reporter these same questions? I mean, because they do it all the time. I've seen news shows where they'll put up the address, the phone number of the school where this person works. Hey, you can find her address right here on the website. But now if I post the address and the phone number, publicly known, public information on the news show, does that somehow make me guilty now under this statute of harassment? Do you see the problem the prosecutor's facing here, guys?
If you can say that, we can move forward. If you can't, then no problem. We will not go forward.
Judge, would the court accept that we acknowledge that she did fear for her safety and that of her family, and that her fear was reasonable, and that she believed her fear was reasonable? We have no argument about that. It's just that he can't put himself in her shoes to know what she thought reasonable was, but we'll agree.
That's the problem with the statute. That's precisely the problem with the statute. It's not based upon an objective, reasonable standard, guys. It's based upon the alleged victim's belief, who happens to be married to a prosecutor who's been doing everything he can to disallow people from recording in court. He just lost the case against Lane Myers. Lane beat her, I guess, at one of these hearings that he had against her. And it just has the appearance that this guy is out for blood and he wants to get Lane. It has the appearance that the husband is orchestrating all of this with his friends in the prosecutor's office. When I took ethics, I was taught that if you're a prosecutor and you've got a situation like this, you need to step as far away from the case as you can. But in this case, it looks like he's taken the lead to take this guy down. It really looks bad. It really, really looks bad to me. And the only way anything is going to change, in my opinion, is if you guys get the local news involved, that you guys start filing petitions for recall and you start running for political office. This is just one guy. This is going to keep happening until we, the people, start taking steps to put people into power who know the law and mean to keep it well and aren't trying to put their careers over the Constitution. Give me a bunch of ones if you agree.
Your Honor, I pulled up the Raji just to see how it kind of is, for.
That's a jury instruction, just so you know, Mr. Myers.
Yeah, the instruction.
We always call them Rajis, I just didn't know if you knew that, sorry.
So, it says the crime of stalking requires proof that the defendant, one, knowingly or intentionally engaged in a course of conduct that was directed toward another person.
And I'm okay, I feel like I've got that.
And then it says, and that conduct caused the victim to reasonably fear for, and then that's where we get to the.
Now listen, I could understand this if there was no connection between the university and the prosecutor's office working for the university or working on stuff with the university, and instead those facts didn't exist. I could understand that if Lane said, here's her home address or here's where she works and she's not a government employee, I could see where this statute might have some teeth in it, at least if it was California or Texas. But I just don't see it. If this was in California or Texas, we're talking about a government employee allegedly married to a prosecutor who has an animus against Lane, who's forwarding charges, who's trying to file petitions to disallow people the right to audio record in court, which is recognized by the Supreme Court of Arizona, based upon facts that don't exist, based upon speculation in his own personal opinion, that somehow recording is going to prevent fair hearings and fair trials, which is absurd. Then I think that we might have something, but we just don't have that here. We have a course in conduct, almost reminiscent of a Monell claim, if I was bringing a civil rights case, of major state action and violations of civil rights, in my opinion, in my humble opinion, having been a civil rights attorney for over 20 years. Guys, this just doesn't look good to me. I don't like it. I do not like this at all. Let's keep going.
Isn't that up to her to determine though?
Okay, so do you agree with me that you engaged in a course of conduct that was directed at Ms. Walker, that being the phone call and the 4 videos?
The phone call only.
Well, why did you put videos up? That was not directed towards her?
Absolutely not. Those are not directed at Shannon Walker. I didn't tag.
And I don't have a course of conduct. One phone call is not enough.
The directed at means that I would say, hey Shannon, or I would tag her in social media, or is a Cake on 9 story directed at the person in the video?
Absolutely. So I'm going to find that there's no factual basis.
So it sounds like the court has just made a finding on the record that Lane's conduct by making a video was directed at Shannon Walker. That's interesting. Is that her name? I don't even know her name. Strike that. Remove that from the record. I don't know who this person is. Let's keep going.
For the plea agreement, I'm going to find that the court has gone through the Donald record and that Mr. Myers is knowingly, intelligently, and voluntarily rejecting the plea because he's unable to provide a factual basis. We're going to affirm the next court date, which I believe is just the trial. Just wanted to make sure. Oh wait, there's a status conference right on July 14th at 9 o'clock.
Are you also allowed to make orders in this case? That to order them, because they've been telling me that I was going to get the pre-trial witnesses for 2 months.
That's a separate order for Judge Metcalf. So no on that one. Okay. All right, but the parties should be prepared to proceed to trial. Thank you, everybody. Thank you for everybody's patience. Do you want to take that? Just because I don't have any of the signatures. Just,
Hey, can you get my name? What's that? That's that bootleg shake with that Chilton. Which one?
All right, so I want to give a shout out, obviously, to both Reluctant Prophet, and this is a public service, for covering these stories and keeping the story alive. Thank God that Lane Myers has that magnetic personality that's caused hundreds and hundreds of thousands of people all across the internet, not just YouTube, but Patreon and TikTok as well as Twitter. He's blowing it up. He's getting millions and millions of views. And I'm doing my best to expose what I believe are injustices in this case, had they been litigated in California or Texas, and just giving you my opinions of how I would have approached this case, not just as a defense attorney, but as a prosecutor, had these cases been brought in a jurisdiction where I'm licensed to practice law. So again, nothing that I've said today should be construed as legal advice. I'm not practicing law as if I was in Arizona. I'm simply trying to give you an understanding as to how I would handle this case if I was there in an Arizona federal court or in California or Texas, and I had been properly admitted into, say, an Arizona federal court. But I just want you guys to see that there are a lot of issues that have come up in this case, and now you had an opportunity to hear from Lane's own mouth what happened. And the judge, you heard her say it, one phone call is not enough. And that phone call that he made, and now my understanding is that the alleged victim said there were multiple calls made by Lane, and I believe she made these statements under penalty of perjury. And if that evidence is excluded from trial, that will be another independent basis for the case to be reversed on appeal. And I believe that it would be an abuse of discretion for the trial judge, if this was in California or Texas, to not allow that evidence in. So my job here today was simply to bring the facts to you guys today and give you an idea of how I feel about it, as if this case was brought in a jurisdiction where I'm legally licensed to practice law. And I don't know Lane. I actually really didn't get to know him at all until after this happened to him. And I was like, well, wait a minute. I saw some of his videos and I was like, wow, this guy really knows his stuff. Yeah, maybe he pisses people off. He cuts people off. He's loud. He's obnoxious. But guess what? That's all constitutionally protected activity. And me as a lawyer and a civil rights advocate, naturally, I'm going to favor that guy who's outspoken, because it connects me to the revolution, because the First Amendment wasn't just about free speech, press, and association. It was about being able to stand up to the government. And I believe that our founding fathers are turning in their graves right now. I believe that Mao Zedong and Joe Stalin are looking up from hell right now, congratulating these prosecutors for what they're doing. In my humble opinion, I believe that this is not justice. I believe that this is unfair. And that's just my personal opinion. So let me just look at some of the comments from y'all in the sidebar here. Simba B says that Metcalf is biased. Lane can't get a fair trial. Well, I can't really I can't form an opinion on that. We'll have to find out if the judge abused his discretion if there is a conviction. Now, the judge also, if this was California or Texas, could just say, you know what, I don't find that this statute is enforceable as applied to Lane's case, and start throwing out charges and force the prosecutor into a position where she has to dismiss or do something that's more fair. In this case, if Lane had not been locked up, I think that he would have been able to prepare an adequate defense, and he would have already had writs filed. But in Lane's own words, the reason why he didn't file these extraordinary writs is because it would have resulted in more jail time, and it would have resulted in his speedy trial rights being basically continued. Now, I don't understand how that works in Arizona, but I'm a guy who's all about filing writs and appeals and creating a record, filing objections, written objections, demanding rulings on the objections, and just creating an outrageously outstanding record to where the appellate court has everything in advance ready to go. So I'm out the door ready to go. And so the only other way a case like this typically is going to get any teeth in it is if you get the news media, the regular press, which these prosecutors and public employees would give respect to, right? Like if this was on 60 Minutes or if this was on CNN, right? They probably wouldn't even like Fox News, because to them that's the Orange Man Network. And we know most government employees are far left Democrats, right? So you'd have to get it on a news channel that they respect. And then that might give him some weight. That might get the attorney general involved. It might start raising eyebrows. Recall elections are another way that gets government employees' attention. But the bottom line is, guys, is the only way things are going to change is if we, the people, get more involved in the system. And I'm not passing judgment on this woman. If she feels that way, then that's up to her to have those personal feelings. But again, when you're a government employee and you have a government email and a government phone number on a government website, and somebody who feels that they've been treated unfairly and they are a public citizen, I don't see any issue with doing a YouTube show and saying, hey, I would like it if you guys would help me petition this government employee for redress. I think that that is a fundamental basic right under natural law for anybody to be able to do that. And hopefully you would agree with me. Give me a bunch of ones if you agree with me. Give me a bunch of twos if you think that I'm a racist, bigot, and homophobe, because that's typically what people call you if they disagree with you in this country nowadays. Now, Mr. Gold says, those stupid enough to bring these charges also don't even know how to bring a case to trial. This is all show to chill speech by others, even more so than just Lane. Well, that's the problem, is the appearance that it gives is that if you talk back to your master, right, which should be your servant, the same thing is going to happen to you. And this is reminiscent of the Tiananmen Square massacre. This reminds me of King George. This reminds me of everything that I, as a United States Marine, when I took that oath, I took an oath to protect and defend the First Amendment, the Second, and all the other ones. And if I was a prosecutor, my job would be to do justice. And if I saw the totality of the circumstances, I've got a pissed off city attorney who doesn't like Lane, who apparently is in cahoots with a public university where they're working on cases or doing something together involving the legal system. And somebody that I just lost a case against is now reaching out to a woman who's involved in this. And she happens to be this guy's wife, right? I'm thinking to myself, you know what, man? I think this guy has got an axe to grind with this defendant. And I'm going to be looking at this case very suspiciously, right? Because it gives the appearance to all of us in the public that it looks like Big Brother is working to silence people who stand up for their rights. And it's very, very scary to me. Give me a bunch of ones if you agree. So, hey, Kevin Bjarnarski, good seeing you, man. And it says here, Warren, you sent messages. I don't know who's Warren. This is a public service. I'm not totally sure what's going on that. Let me see here. So this is pretty cool, though. I really appreciate all you guys joining me today. Gosh, this is a public. Everybody, give me a bunch of ones for this is a public service. He's been covering these shows, and this particular one, it took me 4 episodes, and they're all like over an hour each to cover this one hearing. And so I encourage you guys to like and subscribe to This is a Public Service, to donate money to his channel, super chats, or if he's got a private link where you can give money to a GoFundMe or something. Because look, it says in the Bible that a man is worthy of his hire. And I'm not even saying that you hired him, but these big channels like, YouTube, the big guys that have 1 million subscribers, they've got all these sponsors and they've got people giving them money. And this guy is donating his time to do that. So anything you can do to help This is a Public Service or Reluctant Prophet, definitely. And again, anybody who throws me a super chat or a super sticker, any of those kinds of things, I'm going to put you to the front of the line for questions or comments. If any of you guys did just donate money while I was doing this, I was unable to see them. So please put it in the comments here so I can give you some recognition, because I always do that. And I'm going to scroll up before I leave to make sure I didn't miss anybody, okay? So just give me a second, guys. Man, I got all the cool people here today. Thanks, everybody, for showing up. Let me see here. Robert Stubblefield, thank you. Jeff Hates Pigs, thanks for showing up. Randall Hill, thanks for showing up, buddy. The Tribe, thank you for making it today and joining me on a Sunday. Mr. Gold, so happy to see you here, brother. I'm really, really grateful that you showed up today. Everybody, give me a bunch of ones for the freedom fighter, Mr. Gold. And let's keep on going. The Tribe, Phoenix Design Guy, all these guys that showed up for me today. Man, you guys are awesome. Let me see here. SNS Contracting, Sassy Kisses. I'm going to keep going. I'm just scrolling up to see if anybody deserves some additional recognition here. And then after that, I'm going to go get some chow, hit the gym, make it happen, hit the gun range, go put some rounds down range. Let's see here. Because rights not claimed are considered waived, guys. Make sure to remember that. Marbury versus Madison. If you support the Second Amendment, get your butt to the rifle range and make sure that you're well regulated. And well regulated means well trained, by the way. It doesn't mean government regulations for all you people who went to communist run public universities and were brainwashed by the blue haired mafia. So let's keep going here. I'm looking. Just looking to see if there's anybody that I missed. All right. Doesn't look like there's anything really super duper here that. Hey, Swedish Observer. Good seeing you, my friend. That was nice of you to show up. I mean, we've got guys from Sweden, Norway, all over the world watching us, man. The whole world is watching. What is going on in America? America looks like it's becoming a banana republic like communist China. What the hell is going on, guys? We better do something quick. Because as Benjamin Franklin said, if we don't hang together, we will surely hang separately. So with that being said, guys, I really appreciate you guys joining me today. I know that Kinetic Customs had some other videos he wants me to go over. I was going to do some stuff about Letitia James. Looks like she's looking at about 30 years in prison for mortgage fraud. So all kinds of amazing things happening right now. And you can see how corrupt prosecutors can be just by watching what happened to Donald Trump, right? Politically charged prosecutions, lawfare, trying to prevent him from running for president. I mean, unbelievable stuff happening out there, guys. It happens all the time. So with that being said, make sure to like and subscribe, double tap that screen, make sure to save, because we never know when the thought police are going to take down this channel. Semper Fi, do or die.